Oh man, we have seen with so many anti-AI cases the term that we've been recently using, Vexlit, vexatious litigation, where the litigation itself is used to punish the person or the company or whoever. And there's another term I think we need to bring back. I haven't really heard this term used by anyone other than me in like 20 years, but we used to have a saying online called copybullying. And this is where a copyright action was taken not because a creator is honestly trying to protect their work, but just because they're trying to bully someone else. You know, someone makes a YouTube video against you, and so you file a false DMCA claim to get their video taken down, or do some other kind of copyright action to get their entire channel taken down. That's copybullying. And here we have a case where both are very much in evidence. And this case is True Footage v. Automax AI, and it's fine if you haven't heard of either one of those. If you're not in the real estate appraisal business, then there's no reason why you would have. But we'll talk a little bit about the case and about who they are, but mostly we're going to talk about just how egregious the plaintiffs are being here by their own words. What they've come right out and said. And so now the defendants are moving to dismiss the whole thing on that basis. So they say, plaintiffs' copyright claims, the only basis for federal jurisdiction in this case, are facially deficient as a matter of law. Specifically, the complaint identifies 3 registered copyright works. Under black letter copyright law, registration of a copyrighted work with the U.S. Copyright Office is statutorily required. Moreover, plaintiffs' copyright claims can be based only on allegations that Automax copied registered material, and those claims are limited to material found in the deposit copies filed with the registration of those works. Crucially, plaintiff does not allege that Automax copied any part of the 3 registered works identified in the complaint. Nor does plaintiff allege that Automax even had access to those registered works, and plaintiff has not attached the deposit copies to the complaint, so Automax has no basis to discern whether any of the code it might be alleged to have copied is even protectable in the first place. In sum, because plaintiff fails to allege copying of any material from the registered works identified in the complaint, the copyright claims are facially defective. Automax repeatedly pointed this out to plaintiff, but plaintiff refused to amend to cure the deficiencies and obviate the need for this motion. Instead, plaintiff's counsel expressly admitted, they came right out and said it. Here's what they have come right out and said they were doing. They admitted to Automax's counsel that plaintiff's goal with this action is to destroy its competitor Automax with the litigation process, regardless of the merits of plaintiff's claims. Plaintiff's statements show that its intention is to put Automax through ruinously expensive discovery in a bid to bleed Automax dry and bankrupt the very young startup company with litigation costs. The court should not reward this behavior by merely dismissing the facially defective copyright claims with leave to amend. Given the obvious deficiencies on the face of the complaint and plaintiff's nefarious admission, plaintiff should be expected to provide, in its response to this motion, evidence supporting its alleged good faith belief that Automax copied from any one of the 3 registered works identified in the complaint. If plaintiff does not provide such evidence establishing a good faith basis for its copyright claims, this court should exercise its discretion under Rule 12D, convert Automax's motion to dismiss into one for partial summary judgment, and enter judgment in favor of Automax on plaintiff's copyright claims. Finally, because plaintiff's copyright claims fail as a matter of law, the court should dismiss plaintiff's state law claims for lack of jurisdiction. Alright, so who are these guys? Both plaintiff and defendant Automax AI produce web-based software that aids in real estate appraisal. Plaintiff sells its TrueTrack software to appraisers. Automax's business model is different. Automax makes money by doing appraisals rather than selling its Copilot software. Automax CEO Hamza Ahmed's family has been in the residential real estate appraisal business for 3 generations. Mr. Ahmed decided to pursue a career related to the family business, but from a different angle. He decided to study and work in the field of AI and to apply his skills in designing AI models to aid in real estate appraisal, a business he knows well. Automax builds its Copilot native AI appraisal software for its own appraisers to use, and it also provides that software without charge to independent appraisers in regions where Automax does not have its own appraisers. That's nice of them. I like that. Automax gives away its software to these independent appraisers whether they are performing an independent appraisal for a lender through Automax or not. Automax's aim is to improve the appraisal process and help as many appraisers as possible become familiar with Copilot. And by the way, this has nothing to do with Microsoft's Copilot, it just happens to have the same name. But yeah, that's really nice of them, but as it goes with copyright cases and with anti-AI cases, no good deed goes unpunished. Rather than innovate and update its software to try to compete more effectively with Automax's Copilot, Plaintiff chose instead to sue Automax, alleging facially defective copyright claims. Plaintiff and its counsel are aware that Plaintiff's copyright claims are meritless and defective on their face because Automax's counsel has repeatedly explained it to them. Plaintiff's counsel expressly stated to Automax's counsel that Plaintiff's goal is to bankrupt Automax through litigation regardless of the merits. 2 lawyers representing Automax have provided declarations testifying under penalty of perjury to Plaintiff's admission of its abusive motives for filing this lawsuit. Specifically, Plaintiff's counsel called out multiple times that his client was aware that Automax AI raised millions of dollars in its initial fundraising and said that his client has enough money to make Automax AI spend all of its own money on litigation until it goes out of business. They stated on multiple occasions that Automax AI would not survive litigation, that Automax AI would not have sufficient funds to defend itself in litigation, but that Plaintiff was willing to spend more litigating the case than Automax AI had raised if Automax AI did not accede to True Footage's demands. That's extortion, plain and simple. Usually judges don't like it when you do that. Of course, granted, that's what a lot of these lawsuits tend to be. I mean, the Anthropic settlement, come on, that was extortion. But they usually don't say the quiet part out loud like this. And Plaintiff's counsel admitted that his client's position was that Automax AI could either submit to a complete redesign of its product, or in the alternative, that it would be forced to stop operating because True Footage would put the company out of business by virtue of its ability to spend more than several $1 million, which Automax AI had raised from investors, on litigation. After Plaintiff filed its complaint, Automax's undersigned counsel explained again to Plaintiff's counsel in writing repeatedly why Plaintiff's allegations are insufficient on their face to state the asserted copyright claims. Plaintiff refused to provide any evidence or clarification of its allegations that would indicate Plaintiff had a good faith basis for its copyright claims or obviate the need for this motion. So they have nothing against them. No evidence, no nothing. So they go through some of the nuts and the bolts, and then they point out that Plaintiff must allege that Automax copied protectable code to plead infringement based on copying. That's all you have to do is allege it. And we've seen that in other anti-AI cases where they just do kind of the bare minimum, and it's clear they're shoveling it, but they made the allegation so it can go forward. It's not a high bar. Instead, the complaint serves up a word salad of irrelevancies and abstractions. Plaintiff speculates that Automax entered unspecified TrueFacts components into one or more unspecified generative AI tools, but Plaintiff does not allege what those components include. Nor, crucially, does plaintiff allege that any of those components are part of the front-end code included in the registration. Along similar lines, in the same paragraph, the complaint alleges that a browser logged into TrueTracks automatically downloads JavaScript, cascading style sheets, and other front-end resources needed to display the application. Like all websites do. That's how the web works. But again, plaintiff does not allege that those client-side elements have anything to do with the front-end code included in the registration. Plaintiff's sophisticated counsel surely was aware, even before Automax's counsel explained it, that plaintiff must plead copying of one or more of the specified registered works, and there is every reason to believe that plaintiff's failure to allege that Automax copied code that is registered is no accident or oversight. Given plaintiff's stated intentions to bleed Automax dry via the litigation process, plaintiff's coyness likely is by design. And they go into the technicalities of the software and the charges and the state charges and everything else. And in conclusion, they say, for the foregoing reasons, Automax respectfully requests that the court A. grant summary judgment on the copyright claims, or, in the alternative, dismiss them for failure to state a claim. B. Dismiss the state law claims for lack of federal jurisdiction. Or C. In the alternative, order a more definite statement of the copyright claims. Respectfully submitted, Lex Lumina, who sounds like a Superman villain, and Rhett O. Millsaps II, who sounds like a country music singer. But nope, they're lawyers. Their names would have been better off in other things, but no, they decided to be lawyers. But they did a good filing with this. Every time I think that these plaintiff lawyers in the anti-AI cases can't possibly get any worse, they go and get worse. And there are just so many of these, dozens upon dozens upon dozens upon dozens. And they're all like this. It was just a matter of time before one of them said the quiet part out loud, but here we are. We know what this is. This is not about you have legitimately wronged us. It's about you're a competitor and we're going to take you down. So we'll have to see what the judge says about this. There's no ruling from the judge on the docket as of yet, but there are a whole bunch of declarations that we don't get to see. So we'll have to see how this develops. But man, to just come out and say that, that's not good. Attorneys get disbarred over this kind of thing. And maybe that'll be the result of a lot of these AIs, is that a lot of these attorneys won't be in business anymore, and they'll deserve it. So stick with me as I try to keep you up to date on all of this. Thank you so very much for watching. Comments for the Comment God, shares for the Share Throne. Please hit like, subscribe, and the bell, and of course, donate. Dopagosity.tv keeps me doing this. Whether with one-time donations or regular support, it's all good. So please check all of that out. Thanks again, and until next time, stay strong and be free.